Hello, I'm Sue from Seoul Law Group, and we are an English-speaking law firm based in Seoul, South Korea. We're back with another law video, and today we'll cover everything you need to know about self-defense in Korea. One of our biggest worries when traveling or moving to a new country is safety. It's natural to feel the need to look after oneself, but in many countries, the laws may differ on accountability when it comes to self-defense. To avoid breaking the law in relation to self-defense, Seoul Law Group is here to guide you through this topic so you can travel and live in South Korea with total comfort. What is self-defense? Self-defense is the right to prevent violence through the use of counteracting such force with your own actions. However, this definition can raise many questions such as, what is the level of self-defense one can use if needed? If one goes beyond that level, how is it seen by the law? And what if the victim of self-defense was the one who provoked the attack? Self-defense laws can be more complicated than they seem. And while the South Korean courts have established articles to clearly define self-defense scenarios, judges often view a situation differently. Self-defense according to the Korean law. Article 1 of the South Korean Constitution points out that the country is a democratic republic where the power comes from its people. With this in mind, we can understand that the right to self-defense is everyone's right. Self-defense is stipulated in Article 21(1) of South Korea's Criminal Act. If the court rules that an act was perpetrated in self-defense, then the punishment of the defendant must be dismissed. There are a few important things to note about self-defense based on Article 21(1). Firstly, the infringement should be impending. This means it cannot be self-defense if the infringement was already done in the past. For example, if a person is currently trying to break a window of your home, the infringement is seen as pending, so you can use force to stop them as self-defense. But if the person already broke the window and is running away from you, if you run after them and use violence upon them, it is not seen as self-defense. Please note that whether the infringement is impending or not is judged based on the time of infringement. For instance, if you put in an electronic shock device on your house to prevent thieves from breaking in, and the thief got injured by electrocution while breaking into your house, your action is self-defense. The electronic shock device is designed to work only when the break-in happens, which means the infringement is impending when the device works. Secondly, the infringement should be unjust. It cannot be self-defense if the infringement is not unjust. For example, if a police officer is trying to arrest you unjustly, you can use force to get out of their hands as a form of self-defense. But if the officer is trying to arrest you on legitimate terms, you should obey the police. To be unjust, the infringement should not just be illegal, but should amount to a crime. For instance, borrowing another person's money and not paying it back is illegal, but not a crime. So if someone borrows your money and does not pay it back, and you steal their money to cover that debt, your action is not self-defense. Also, if the infringement is provoked by the victim, then their actions are not recognized as self-defense or recognized only to a very limited extent. For instance, if you first tried to kill the victim, it is not self-defense for you to kill the victim, even if the victim fought back. Thirdly, there should be reasonable grounds. This is the most controversial factor when deciding whether an act constitutes self-defense. Regarding this issue, the Korean court has set out several criteria. The defense action should be an adequate means to immediately and effectively eliminate the infringement. Also, if there are several means available for defense, then you should choose the means that inflict the least loss on the other party. Also, these reasonable grounds are judged much more strictly if the infringement is not very serious. For instance, there was a case where a woman tried to steal a few chestnuts. A man who was the owner of the chestnut tree beat the woman and injured her. His action was not recognized as self-defense because it lacked reasonable grounds. For these kinds of cases which satisfy impending and unjust infringement but lack reasonable grounds, Article 21(2) can be applied. Excessive self-defense is a kind of self-defense in which the defense act has exceeded normal limits. In this case, the punishment for the defendant does not get dismissed, but may be mitigated or remitted according to the circumstances of the act. When a person commits excessive self-defense, but it was only because of fear, surprise, excitement, or confusion in the night, or other extraordinary circumstances, their punishment should be dismissed as if it is normal self-defense. This is based on Article 21(3). For instance, there was a case where a man, his wife, and his niece were walking down the street late at night. The victim, heavily drunk, suddenly came out of nowhere and attacked the wife and niece, even when they tried to escape. When the victim knocked down the wife and tried to hit her with a stone, the man kicked the victim to protect his wife, killing the victim. The court recognized this man's action as excessive self-defense, but decided not to punish him because it was caused by fear, surprise, excitement, or confusion in the night. Self-defense case study. Unfortunately, in reality, self-defense might at times not be seen as properly implemented, thereby labeling the act as a violent reciprocation worthy of punishment. In Korea, this is a regular occurrence, as well as in many other countries around the world. If the perpetrator is injured in the process of removing themselves from the situation, or is damaged by what the judge considers to be merciless aggression, the case can become a two-way assault case. To understand this more clearly, we will provide some example cases in the following section. It is important to note that while this is a common outcome, it is not impossible to win a self-defense case in Korea. Case number 1. In 1964, when a woman was 18 years old, she was sentenced to 10 months in prison and 2 years probation for biting the tongue of a victim who kissed her against her will. Although the defendant claimed it was self-defense, her argument was not accepted and she was declared guilty of aggravated bodily injury. With the Me Too movement gaining traction in recent years, the case gathered national attention in 2021. Thankfully, the court's view on this case has changed since then. In a similar case in 1989, a completely different verdict was handed down. The victim was a man who assaulted a woman and kissed her against her will. Then the woman bit off the victim's tongue and severed it. The court declared the defendant not guilty because her action was self-defense to protect herself. Case 2. In 1991, the defendant who had been suffering from domestic violence for a long time killed the attacker. The defendant had been exposed to threats of murder on a regular basis for over a decade, and at the time when the crime happened, she was being beaten mercilessly while she was pregnant. Of course, the defendant claimed self-defense, but was nevertheless sentenced to 3 years during the first trial. Many felt that it was an opportunity to bring prejudice against housewives in Korea to the surface. The trial continued with the final outcome of 3 years in prison and 5 years probation. The story does have one positive outcome, as the case led to the formation of the Special Act on Domestic Violence in 1997. Sadly, the court's view on this case hasn't changed much since then. A similar case in 2001 saw the same outcome. The defendant was a longtime victim of domestic violence who killed the attacker to protect herself while being beaten. Many Korean scholars have criticized the outcome of this case, arguing that this case should have been self-defense, or at least excessive self-defense. Case 3. There was a case where a police officer shot a victim in his chest, instantly killing him because he resisted with a knife. The action of the police officer was not recognized as self-defense because there were other options for subduing him without killing him, such as using a gas gun or shooting a non-vital body part, such as a leg. Case 4. A brother beat his sister while her husband was watching, so a fight between the two men broke out. The brother was a large man, while the husband was smaller by about 20 kilograms. When the brother threw down the husband and straddled his chest, he pressed against his neck. The husband grabbed a fruit knife to stab the brother in the leg. The husband was charged with bodily injury despite pleading self-defense. What to do when being attacked in Korea? There are several actions you can take when you feel you are being attacked in South Korea. Firstly, if possible, contact the police. You should not be on your own or ask for help of strangers when facing a serious or potential threat. To contact the Korean police, dial 112. Secondly, consider the duty to retreat. Many courts advocate that victims first make an attempt to avoid further confrontation before relying on violence. Your case will look stronger if you first make an attempt to escape the situation rather than applying force from the start. Thirdly, contact your respective embassy. If you are a foreigner in Korea, your embassy is there to help you thrive and live comfortably in South Korea. Embassies have a duty to care for their citizens who are living and working in South Korea. Contact your embassy after an attack to see all available support options. Lastly, contact a lawyer such as Seoul Law Group. Lawyers in Korea are trained to deal with self-defense cases and have many years of experience navigating the tricky world of Korean courts. A lawyer will not only take control of your case, but make you feel safe in the process. Additionally, if your attack has left you with mental health concerns, be sure to seek out the help of a therapist, psychologist, or doctor. Taking care of your mental health is just as important as your physical health. It is important in the future to create healthy environments and conditions for victims to escape violence. Seoul Law Group firmly believes in clearly identifying who faces a threat, who made the preemptive attack, who controlled the situation, and to distinguish unilateral violence. It is our firm belief that society as a whole has a right to protect their lives and that the cycle of victims being treated unfairly should not be ignored in future cases. I hope this video was useful for you. If you have any questions, let us know in the comment section below, and you can find more information on soullawgroup.com. Don't forget to like, subscribe to our channel, and turn on that notification bell for more Korean law videos, and we hope to see you next time. Bye.